We are on to question 4 from the July 2024 California Bar Exam. Put this in context. Question 4 means that this was the first essay to respond to in the afternoon in a 3.5-hour test session where you had 2 one-hour essays and 1 90-minute performance test. You have to get your timing down tight. Can't go over an hour on this one. The first call, did the court err in seating juror number 5? Is that a crim pro call? It's certainly rooted in the Sixth Amendment. Call 2, did the court correctly deny Palma's motion for directed verdict? Directed verdict, that is a civil procedure call. Call 3, how should the court rule on Palma's motion for a new trial? Motion for a new trial is also a civil procedure call. All right, we have 4 paragraphs of facts. It's likely that the first paragraph is background facts, the second paragraph goes to call 1, the third paragraph goes to call 2, the fourth paragraph goes to call 3. But let's see. A car manufactured by Motor was in an accident. Palma, P name, that's the plaintiff, was in the front passenger seat during the accident when her seat collapsed, resulting in serious injuries. Palma properly filed and served a complaint in California Superior Court against the manufacturer, Motor, asserting defective seat design. So they've given us a products liability lawsuit, and they've also now told us that we need to respond with California civil procedure and not federal civil procedure. So call 1 is also within California civil procedure. They were very specific about the theory of the case. It's not only a products liability lawsuit. They gave us the theory of the breach, defective seat design. We're likely to need that when we come to the call about directed verdict. The standard for a court to decide to grant a directed verdict is no legally sufficient evidentiary basis for a reasonable jury to reach a different conclusion. So let's see what we get. First, we need to deal with the jury issue. During jury selection, juror number 5 revealed that she had worked as a motor engineer before retiring 5 years ago. Juror number 5 also disclosed that she still owned 50 shares of Motor stock, which amounts to 2% of her total financial assets. So, evidence of potential bias here, right? Palma challenged the seating of juror number 5 for cause. The court denied Palma's challenge because juror number 5 said she could be fair and impartial. Okay, stop here. What do we know about the law regarding jury selection from the Sixth Amendment, from California civil procedure? Let's look at the law. I'm going over to Proponix, our software platform where we have loaded all of the law we felt we needed to memorize for the bar exam. And I'm going to criminal procedure because that's where we have our basic analysis of Sixth Amendment rights and protections. The Sixth Amendment guarantees the right in a criminal prosecution. The Seventh Amendment extends it to civil cases with a value over $20. Okay, so here we have the jury must be a cross-section of the community comprised of at least 6 members, and the jury must be impartial. The issue here is the issue of bias. When may a juror be excluded for cause because of bias? There are 2 kinds of bias, actual and implied. And what we're dealing with here is implied bias in these facts. Actual bias exists when something about the case or the parties makes it so that this juror cannot act with impartiality. Implied bias is where facts in the judgment of law, in other words, in the decision of the court, would disqualify the juror. I'm going to want to show the grader that I know the difference between those two. If they had told us that this witness still works for Motor, gains her entire income from Motor, then I would argue that there's actual bias. But this is a retired worker who has only 2% of her holdings in Motor stock. So I think we're dealing with implied bias here rather than actual bias. Back to the hypothetical. Palma challenged the seating of juror number 5 for cause. Okay, so stop and think about that one. There are two kinds of challenges to the seating of a juror: for cause and peremptory. You have a very limited number of peremptory challenges. In California, in a civil case, it's 6. You have unlimited challenges for cause, and there's a big difference between the two. The court shall exclude a juror who is peremptorily challenged off. But when the challenge is for cause, notice what we saw on implied bias. It's when the existence of the facts as ascertained in the judgment of law disqualifies the juror. In other words, it's the judge's decision. This hypothetical tells us the court denied Palma's challenge because juror number 5 said she could be fair and impartial. In other words, the judge, looking at those facts and what the juror said, decided that there was no cause to exclude her. So my answer to call 1 is going to be no, the court did not err. The standard is whether the juror can be fair and impartial, and the juror said she could. So the judge denied the challenge appropriately. In the next paragraph, we see that during trial, Motor presented evidence that the seat was not defective and that any injuries Palma suffered were due to reclining the seat to an unsafe angle. Palma submitted evidence that at the time of the accident, a bookshelf was in the back seat, which prevented excessive reclining. At the close of evidence, Palma moved for directed verdict, arguing that misusing a product is not a defense to defective design when that misuse is foreseeable. The court denied Palma's motion, and a jury verdict was issued in favor of Motor. Okay, let's stop and take a look at the law and come back to this. So I'm going to go to California Civil Procedure. Our civil procedure schemas are divided into 2 parts. It's such a huge subject. All of the discovery through trial and post-trial issues are in Part 2. So here we go with Part 2 and trial issues, and down here we see directed verdict. And what do we have? It's a motion made during a bench or jury trial asserting that there is no legally sufficient evidentiary basis for a jury to find for the other party. And when there's a motion like this, you always have to worry about whether the timing was appropriate. A motion for directed verdict is made at the close of both parties' evidence. That's what happened here. So let's go back to the hypothetical and think about this. And I will tell you that I find this call to be really difficult for this reason. Look at what the hypothetical says. Not just Palma moved for directed verdict, but that she moved for directed verdict arguing that misusing a product is not a defense to defective design when that misuse is foreseeable. So she moved for a directed verdict only on the point of defense, not on the main cause of action defective design. Now, is that a valid defense to defective design? So I got sidetracked into thinking about tort law, about strict liability, products liability, and the fact that some jurisdictions accept a misuse defense and some don't. But even in the jurisdictions that accept that kind of a defense, a misuse that's foreseeable is not a valid defense. So I think she would be right in any jurisdiction. But that's not the main point of this call. This is about civil procedure. This is about when can you ask for a directed verdict? When can you be granted a directed verdict? Remember the standard. There has to be no legally sufficient evidentiary basis for a reasonable jury to reach a different conclusion. Look at what we have. We have that Motor presented evidence that any injuries Palma suffered were due to reclining the seat to an unsafe angle. She presented evidence that she couldn't have done that because she had a bookcase in the back seat. There is evidence presented by each side. So a jury is going to have to decide what they believe, what they think the correct evidence is. That she reclined the seat too far, or that she couldn't have because there was a bookcase in the back seat. And beyond that, whether her misuse was foreseeable or not. The judge, in his ruling, is saying there is sufficient evidentiary basis for a reasonable jury to reach either conclusion, a different conclusion from hers. So he was correct to deny her a directed verdict. That's where this stands. And the last paragraph has to go to the third call. 2 weeks after the jury verdict and judgment, Palma received anonymous reports of motor safety tests conducted 3 years earlier. The reports showed that severe injuries were likely, regardless of the angle of the seats. 1 week after receiving the reports, Palma filed a motion for a new trial, arguing that the verdict was flawed and provided evidence that Motor had intentionally hidden the reports. So this goes to call 3, motion for a new trial. As I said earlier, when you get a motion in a civil procedure fact pattern, you have to worry about the standard of analysis for the motion, but you also have to worry about timing. And that's why I find this call particularly nasty. Let's go back to the law. But now we want to look at post-trial issues. So let's get the trial issues closed up, get down to post-trial issues, open that up, and look at motion for a new trial. The verdict may be vacated in whole or in part, and a new trial granted for any of 7 causes. Let's open that up and see what they are. Look at the fourth one, newly discovered material evidence that you could not with reasonable diligence have discovered and produced at the trial. That's exactly the scenario they've painted for us here. So she has grounds to vacate the jury verdict in whole or in part. And I would want to tell them that's standard. But the kicker here is look at the time limits. Within 15 days of the date of mailing notice of entry of judgment by the clerk of the court. And there's more detail there, but basically the rule is you have to file that motion within 15 days of knowing about the verdict. Recall what we had in this hypothetical. Let's go back to it. That last paragraph says 2 weeks after the jury verdict and judgment, Palma received anonymous reports of motor safety tests conducted 3 years earlier. 2 weeks after the jury verdict and judgment. The clerk of the court has 24 hours to enter the judgment. So we're 13 or 14 days past the entry of that judgment. So she's within the time limit right now. The report showed that severe injuries were likely. 1 week after receiving the reports, Palma filed a motion for a new trial. So we are 20 or 21 days out from the entry of the judgment. And that's past the time limit. So look at how nasty that is. They gave you grounds for her motion for a new trial, but then they told you that she had missed the time limit. So the court should rule against her in the motion for a new trial. They should deny that motion. Now, what if you hadn't memorized that? You didn't know the time limit, and so you thought that the motion should be granted. Is that going to make you fail this essay? No, I sincerely doubt that it will make you fail the essay. I think that it's likely that less than half the candidates in this exam knew that 15-day time limit. What do you do if you get a post-trial motion in a hypothetical and you don't know what the time limit is? Well, most of them are 15 days. So I would tell the grader that the time limit is likely 15 days and analyze it that way. So where do we stand on this whole essay? Well, the level of detail that you needed to know in order to do a really stunning job of answering this was pretty extreme. But I suspect that there will be a lot of leeway in the grading because California civil procedure has very rarely been tested, and this really did contain very specific trial and post-trial motions rather than broader issues. When the essay is really hard for everyone, then the grading gets really much more lenient. You have a lot more leeway for the way in which you analyze things. Good for you if you've reached this point in this debrief. I realize the debriefs are quite long and quite detailed. If you need more help with the law, more detailed review of the law, we have past lectures that were recorded and that are in our Patreon channel. What would help us the most is if you would subscribe to the channel and put a like on the video, because you know how YouTube works. It will get it out to more people if we get likes and subscribes and comments.